Oh, it's lots of pages. All right, let me hold this for a minute so I can go through that. I did not see it. I said, no, you did. Well, I can't use it this minute. They need, if they're gonna do a response, I need it before. No, it's not you being sorry. I don't need to. This is Mr. Coleman's case?
Yes, sir.
Are you prepared to argue?
Yes, sir.
Okay, I'm not gonna, I mean, this was filed this morning, so I'm not gonna take. Come on back up. Let's just do it. All right, so you're Larry Fletcher Jr.
Yes, Your
And this is clause numbers 25 DCCR 0838 and 0839. Mr. Fletcher's charged with aggravated assault with a deadly weapon and manslaughter. There's a motion that has been filed to modify the conditions of bond. That he cannot operate a motor vehicle. And so, Mr. Gertz, go ahead.
Judge, I think you're familiar with the facts of this case because we had a hearing on a motion to revoke probation. And the issue in that hearing was about causation of the accident. And the court decided that the issue was serious enough to hold that in abeyance pending trial on of these two cases. And my request here is based on the fact that Mr. Fletcher has been following all of these bond conditions, following the rules the court set, but is having difficulty getting to and from work and doing other things that he needs to be doing to be a productive member of society. He's not allowed to drive. And so, this was not an it's not an intoxication manslaughter case. It's just a manslaughter. It's just an allegation of reckless driving.
The problem is the history of reckless driving. And so what the state has provided, it looks like, is that there was a 2010 non-injury crash, 2012 non-injury crash, a 2012 maximum speed limit issue, 2013 speeding over 10% over the posted, 2016 speeding greater than 15 miles over, 2018 a non-injury crash, 2021 a non-injury crash. Based on my knowledge, what was presented at that hearing, regardless of causation, there was definitely a speeding issue. That was clear from the black box in the testimony, that there was a large speeding issue. And so I am not inclined to change the bond. Mr. Nichols, does this?
That was the basis of the state's argument, Your Honor, was that his history of crashes and of speeding poses a danger to the public, and that's why we were opposed to altering these conditions.
The court explains that everyone became aware of the newly raised issues at nearly the same moment because the filing arrived late on Friday afternoon. The judge notes that the situation is what it is for now and makes it clear that if any information contained in the filing turns out to be inaccurate, the defense can bring those concerns back before the court through an additional motion. At this stage, however, the request to change the bond and its conditions is denied. The judge then confirms that the case is already scheduled for trial and will remain on the trial docket moving forward. The court also emphasizes that if any facts have changed or if something presented is no longer correct, those matters should be reported promptly so they can be addressed. Attention then shifts to a supplemental motion related to probation, which may have been submitted or may still be in the process of being filed. The defense states that it intends to challenge those allegations and enter a not true plea when the matter is heard. The judge responds that any motion concerning probation revocation will be handled separately at the appropriate time. To close the discussion, the court confirms that the current docket only includes the trial cases and does not include any probation revocation proceedings at this point, which keeps the focus solely on the matters already set for trial.
And the only two cases are on here are the trial cases, not the motion to revoke cases on our docket, correct? Okay. All right. If something comes through that I need to hear, but my thought is still to go forward with the trials first and then to deal with the probation.
I understand.
Unless there's something else significant, another new case or something.
I'm not aware of anything, Your Honor.
Okay.
Well, and let me back up and say, it's not a new case. In the wake of the motion to revoke probation hearing, Mr. Coleman filed a federal case relating to the
The gun that
other
was
thought.
found?
Yeah.
Okay.
So and he's not a convicted felon, but we'll argue that when it's time to argue that. But that's what the new case is.
Okay. That was something that I've already heard in that motion to revoke to some extent.
Correct. Yeah.
Okay. All right. We'll see you back at the trial date then. Good morning. Are you Leandre Simi?
Yes, good morning.
And this is cause number 23 DCCR 0628. Mr.
The court then turns its attention to a long-running case involving a charge of criminally negligent homicide. Discussion begins with the acknowledgement that the matter had previously been placed on the trial docket before being transferred to another court process and has now returned for review before this judge. The defense explains that because of the defendant's immigration circumstances and other related concerns, it is important for the case to move toward a trial rather than remain unresolved. At the same time, the attorneys indicate that there may still be room for productive discussions before any final decisions are made. One side notes that the case has been pending for a considerable amount of time and requests an opportunity to speak privately with the court when appropriate to address several outstanding issues connected to its return. The judge recognizes the concerns and agrees that additional review would be helpful before placing the matter directly back into the active trial schedule. As a result, the parties discuss setting a future review date to evaluate progress and determine the next steps. The court agrees to schedule a review in approximately 3 weeks, giving both sides time to continue discussions and examine the remaining issues. Attention then shifts to the practical challenge of travel since the defendant currently resides in Florida. The defense asks whether the upcoming review can proceed without requiring a lengthy trip and whether the appearance requirement can be adjusted for that hearing. The conversation ends with the court considering that request while working toward a more efficient path forward for the case.
Was it the kind of thing that we could do a review and just note that he doesn't need to come from Florida, or does he need to come back for that?
Well, if we're going to put it on the trial docket at that point, I'll need a rejection. So I don't know if y'all want to
We've done a rejection previously, I believe, Judge.
see.
You don't see it? Yeah. It's not,
Because of that.
I know.
But they also, yeah.
It's fine, Judge. He'll comply with whatever.
I mean, I can do 4 weeks. I can do a normal reset if
That's
that
fine.
helps. And then let's just do a normal reset and then we'll get all on the same page on that date. Okay.
Good. Thanks, Judge.
All right. All right, ma'am, you're Ibriana Bell again, correct?
Yes, ma'am.
And we've already gone through that she entered a plea of guilty. Well, actually, let's go back because I don't even think I went too far with all of that. Will she waive the formal reading of the indictment?
Sure.
So, Ms. Bell, in cause number 25 DCCR 1610, you're charged with the state jail felony offense of theft of property with previous convictions from August 14th of 2025. And how do you plead to that charge? And then
The hearing then moves into a formal review of the defendant's plea and prior record. The court references earlier convictions listed in the indictment and asks whether those allegations are true. The defendant confirms that they are true and further states that the decision to enter a guilty plea was made willingly and without pressure. The judge carefully verifies that the plea is being entered because the defendant accepts responsibility for the conduct described in the charge. Attention then turns to several legal documents that have been signed and submitted to the court. The defendant confirms that each document was reviewed with legal counsel before signing and states that the contents are fully understood. The court also makes sure the defendant understands the legal consequences of the agreement, including the surrender of certain appeal rights if the negotiated resolution is accepted. Once that is established, the discussion shifts to the agreement reached between the parties. The attorneys explain that they have agreed on a sentence involving probation rather than immediate confinement, along with a financial obligation that must be paid. The court reviews the details of the recommendation and asks whether any corrections need to be made to accurately reflect the agreement. The parties confirm the terms and indicate that they have no objection to the court updating the paperwork so that it matches the final negotiated resolution. With those confirmations on the record, the case moves one step closer to a formal conclusion.
Correct, Your Honor. And I have no objection to the court making those changes.
That's the current agreement, Your Honor, as reflected in the altered or corrected punishment recommendation, agreed punishment recommendation.
All right, so what the agreement is for a 2-year term in the state jail prison, that would be probated for 3 years. You would be ordered to pay a $500 fine as well as restitution in the amount of $221. Is that your understanding? Yes, ma'am. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Mm-hmm. State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Ms. Bell is not competent?
No, I'm aware of it.
Great, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That's going to give me more information about you, your case, your history, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. Yes. All right, we'll see you back at sentencing. Miss Bell. Hey, Miss Bell, come back for a sec. If I test you this morning, you gonna have anything in your system? No, ma'am. Okay, just double check that, okay? Have a seat right over there so I know for sure. All right, so you're just in pain?
The court next addresses a serious felony case involving an allegation of aggravated assault with a deadly weapon connected to an incident from September 2025. The judge carefully explains the charge and outlines the potential consequences if the case proceeds to trial and results in a conviction. The defendant is informed that the sentencing range could involve a substantial prison term and is asked to confirm that those possible outcomes are fully understood. The court then reviews documents that show a plea offer had previously been presented by the prosecution. Under that proposal, the defendant would have received deferred probation for a specified period along with a financial penalty rather than facing the uncertainty of trial. The judge makes it clear that accepting or rejecting the offer is entirely the defendant's decision and that no one is required to agree to a plea arrangement. At the same time, the court wants to ensure that the defendant understands every available option and the different paths the case could take from this point forward. After confirming that the information has been understood, the defendant indicates a desire to reject the offer and move ahead toward a trial. The discussion then shifts to whether there is any possibility that the proposal could change in the future or whether additional evidence is still being gathered that might affect negotiations. Before setting the next course of action, the court seeks clarification on any remaining issues that could influence how the case progresses in the weeks ahead.
Judge.
Any evidence that you're waiting on? All right, so I want to make sure you understand, Mr. Payne, that after today, I will not accept this plea agreement unless there is new information that your attorney or the district attorney doesn't have right now. So if you want to go to trial, we'll get your case set on the trial docket. We'll let a jury decide. I just don't want you to place it on the trial docket thinking that somehow it's going to go away or it's going to get better offer. Do you understand?
All right. Always a chance.
Well, I mean, it can get dismissed, but if that's not on the table right now, and I won't accept this later, you understand? And do you want to go forward with setting your case for trial? All right, we'll get it set on the trial docket. Stay in touch with Mr. Kindler. He'll begin preparation for trial, and we'll see you back on the trial date. All right, this is clause number 25, DCCR 1253. Mr. Wars tested positive for THC, methamphetamines, amphetamines, and ecstasy, MDMA. So we are here on a sentencing. Obviously, he's not in a position today to understand the sentencing. So what I'm going to do at this time, I'm not going to reject the offer. There might be some things still that would be considered because of the nature of that offense with the probation, but I cannot obviously do it with his current state of mind. So I'm going to revoke Mr. Ward's bond based on the nature of the offense, which is a driving while intoxicated, third or more. How'd you get here today? You got a ride or you drove? Okay. So I'm going to revoke the bond at this time. There will be no bond. I'm resetting the case till next Monday for sentencing. And then I'll decide at that point whether or not I follow the agreement. And if so, Tuesday. Tuesday. He'll be in custody Tuesday. I'll reset the case for next Tuesday for sentencing, and then if I go along with the agreement, I'll figure out what additional conditions, which I already had
PSI recommended ISF.
ISF already, but it might be something a little more lengthy than that. Go with the bailiff. Thank you.
Judge, I can get with the counselor to let her know about today
Okay,
and see if there might be.
something different. It was ISF substance was recommended, but just based on this, he's obviously in a terrible position. He tested positive at the PSI as well. So maybe Safe P would be something that would be a little more
Or a nap. Well,
a
let's have
long
about
nap.
hour, half,
He's
half.
about to get a nap. Miss Bell, come on back up.
Your Honor, have a nice day.
Everything okay?
Yeah, I know I ain't nothing in my system.
No, you don't, but you also don't have a bad attitude about me checking, okay?
Yes, ma'am.
I check it different people for different reasons. There's no reason to have an attitude. And there's definitely no reason to have an attitude with the nice lady that's standing behind you.
I have an attitude.
Okay, all right. So you tested negative, that's great. And so I'm going to reset. I can't remember now what we were doing on your case, but
PSI.
okay. Stop and talk to probation on your way out, and we'll see you back at Center Clause. That's very important that you're here on time.
Yes, ma'am.
I know you're driving in, but it's your bonds were forfeited, and obviously you don't want to go to jail for being late. I'm going to recall that. Your case is set for trial for next Monday. Mr. Gertz was already here, and you need to stay in touch with his office because I'll number the cases tomorrow.
Yes.
But in all likelihood, you'll need to be back next Monday at 1:00 for your trial.
Yes, ma'am.
Okay, you're free to go.
Thank you so much.
Good morning, sir. You're John Tat Taylor.
Yes, ma'am.
And this is clause number 25 DCCR 1427. Mr. Taylor's charged with fraudulent use or possession of credit or debit cards. And Mr. Reynolds, what is the announcement?
Judge, we received the discovery in his case. He lives in Fort Worth. He has not been by my office so I could review it with him. I received an offer from the district attorney. I don't want to reject the offer till I'm able to go over that with him and ask maybe for a 30-day reset. Let us get that done.
So, Mr. Taylor, I'll reset your case a normal reset, which is about 30 days. You need to make an appointment and visit with Mr. Reynolds before that next court date. If you can do it while you're in town, great. If not, you're going to have to make a trip to come visit with him so that we can know what to do with your case next time, okay?
Yes, ma'am.
All right, you're free to go. Thank you.
Okay, thank you.
Thanks, Joe.
Your Honor, my apologies to the court. I was in the 245th for a family law trial that happened.
All right, thank you. And thank you, sir. And ma'am, you're Deshaun Robertson. This is cause number 25 DCCR 0914. Ms. Robertson is charged with aggravated assault with a deadly weapon. And what is the announcement?
Yes, Your Honor, we have no announcement today. However, we're requesting a push from the court to give a mitigation packet to the prosecution in this case,
What do you mean a push from the court?
an extra date.
I think a reset, Judge. Mr. Naismith has advised me he is preparing a mitigation packet for Mr. Nichols and would like to sit down with him and discuss in person some things that may change the offer. The offer now is a pen time offer, not a probation offer. There is a cap made in the case. So I don't know that mitigation packet may either alter the offer or help Luke explain the cap to you, counsel.
Okay. So what I'll do, it looks like you filed a notice of representation back in December.
Yes,
So this will be the final reset for an announcement.
yes, Your Honor.
And so on that date, either it gets taken care of at the plea, or at that point, there'll need to be a rejection of any offer and it'll move to the trial docket.
An announcement that day as well. Rejection announcement that day too.
Yeah,
I've explained to him when it goes on this course trial docket, it is intended to be a trial.
yes. Yeah, there's no putting it on the trial docket and it not going to trial. It either goes to trial, or if there's some different negotiation, it would be because there's new information. I don't take the plea agreement after that date.
Yes, Your Honor.
So once it's on the trial docket, it's either a trial, or if it's something different, it's because there's more information that's for some reason y'all didn't know.
Yes, it was a HIPAA release. I took care of that 5 days on that.
Okay.
For our mitigation packet, I'll get it to you.
Okay, sounds good. Then we'll just do a normal reset. Obviously this should have been taken care of quite some time ago. I know Ms. Holmes sent you an email back in April
She did.
that we needed that. So there will be no reason, that cannot be a reason for another reset.
It's not.
I'll get that signed today for that investigator, but it won't be a reset based on that, okay?
Yes, Your Honor.
All right, stay in touch with your attorney. He'll let you know when you need to be back.
Yes, Your
All right, thank you.
Honor.